Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about the third-party doctrine and data privacy. The third-party doctrine is a legal doctrine in the U.S. and it's been codified in many laws over decades that data or information that's held by a third party doesn't have the same protection as data that you have in your surroundings. So, for example, the Fourth Amendment of the Constitution in the United States has a clause against unreasonable search and seizure, and that has been interpreted through the years to mean search and seizure of your immediate surroundings, your belongings, your home, things like that, without a warrant. So for decades now, even starting with precedents set in cases back in the 60s, with the Katz case, I think in 1967, we're setting precedents about the differences between information that's held within your immediate control and things that are outside of your control or held by a third party. The problem with the third-party doctrine is it was developed during a time before the internet, before people were storing things online, and before the internet had capabilities to store things in a secure fashion. So, for example, let's say you have a document or a letter in your house that you think is personal amongst your personal possessions. A court order would be needed to actually search your house to find that document. But if that document were, for example, held by a cloud vendor, even if you were having them keep it for safekeeping and it was only for you to access, a warrant may not necessarily be needed in that regard. So there is a vast gulf between the third-party doctrine and what we consider our privacy protections under the Fourth Amendment. One, what I call a rickety bridge between the third-party doctrine and the Fourth Amendment is a case that came up in 2018 called the Carpenter case. So the Carpenter case was about a cell phone search and whether a law enforcement needed a warrant to search someone's cell phone. So this is a landmark decision. Currently, it's the most current and probably the closest ever currently to bridging the gap between the third-party doctrine and the Fourth Amendment, where that was ruled that that you do need, law enforcement does need a warrant to search a cell phone. Now, the issue is our cell phones really are gateways to other information. So just because you have a cell phone in your hand, a lot of the information that you have may be online or in the cloud. So there has to be, in order for there to be a real deep law in the U.S. federally about data privacy, there has to be some joining or reconciliation between the Fourth Amendment and the third-party doctrine. So it remains to be seen. It's not on anyone's radar right now, but there's definitely rulings that are coming into play where the Supreme Court does not really want to legislate. They really want these laws to come through legislation as opposed to ruling. So it remains to be seen how this is going to play out in the legislature. Currently, especially because of the current global pandemic, it's not on anyone's wish list right now to deal with federal data privacy issues. But as we see right now, there are so many privacy issues to be had or to be thought about. So this is something that really needs a type of reconciliation between the two. That's it. Thank you.